So first of all, thank you everyone. Thank you, Dennis. Thank you, Vesna. Thank you, Marco, and the whole team. Let me call you by your own names and take off professors and other titles, because after so many months and projects working together, we are friends. We have to build trust, and I think calling ourselves by our names may help. I wish I was there now, as we were a few months ago. Even better, I wish we were in the boat with some of you dancing, some others trying to sing and having a lot of fun, but I hope we may have the opportunity to meet personally again, but otherwise, let's try to do this online, and I promise to try to do it in 10 minutes, so I will do my best. The structure of my presentation is the following. We try to deal with default judgments and their effects, and I'm going to try to refer some of the fundamental matters through two cases, actually one case of the Court of Justice and one opinion of the Advocate General Cocotte, and then we may try to bring to the table the issue that we have to address in our project, why enforcement of default judgment is problematic in cross-border practice, and we as a group may have to provide good practices and recommendations to minimize the problems that are coming from the default judgment execution. So I know all of you know what is a default judgment, but if you look at the legal framework, we don't have to look just at the recast Brussels regulation, which has gathered and improved the system notably. We also have to look to the Charter of Fundamental Rights, because as you may see, some of the judicial cooperation in civil and commercial matters are affected directly by fundamental rights. For instance, the exclusion of legal persons from legal aid, omissions of reasons in a judgment by default, fictitious services upon a defendant, and other matters. And this has been already referred in several cases. And then, since the UK is leaving the European Union after Brexit, and we have already listened to the US contribution on certain matters that are very relevant, we have to look very carefully to the development of the 2019 Hague Convention, which is willing to provide a single uniform instrument that is much inspired in the European system. So if you look at the whereas of the recast regulation, it's important to see how the defendant is given the opportunity to arrange for his defense. It's not just a question of notice, of appearance. It's also a question of providing the defendant with the opportunity to arrange for his defense. If you go into the Article 45(1)(b), it's not just appearance, it's not just being served, as I said, it's being able to arrange for his defense. So when we are talking about the free circulation of judgments, and we are willing to understand what may happen in default judgment, we have to distinguish between main procedures and provisional or protective orders, which may not be fundamental from an European point of view for the execution of the judgment. I don't want to go into all the details for the sake of time, but if you look at the effect of a judgment of a provisional or any protective measures that are not falling under the definition of a judgment, they must be limited to the territory. They cannot be having an European effect, because that will considerably limit the scope of the regulation. So if you look at the Levitt case, this case is a very common case, maintenance obtained in Poland, and that has to be executed in France, 300 euros per month, wrong address provided, it cannot be executed, and therefore the Polish courts of appeal rejected, and based on certain matters that we will see now, the execution is not feasible. So the Supreme Court in Poland asked for a preliminary ruling for the recognition in Poland of the enforceability of a French judgment. And if you look at the question, what this refers to still refers to Brussels 1, but it says that could Brussels 1 regulation be interpreted as meaning that the possibility of commencing proceedings to challenge a judgment laid down therein within the time limit laid down in national proceedings is sufficient for a relief? If you go into the, sorry, this is not there. Hold on. You go into Article 9 of Regulation of Service of Documents. Again, it refers to the general cases of default judgment when the defendant does not appear or is not serviced. But let's look at the last two paragraphs. When there is a case of application for relief that has to be done in a reasonable time, and in the last paragraph, the European regulation says reasonable time shall in no case be less than 1 year. So these two rules are fundamental for what we are trying to share with you regarding the default judgment. If you see at the question here, the second question of the Supreme Court in Poland was, is it possible any relief from the effect of the expired time of the appeal? That means the time for relief had expired, but could it be possible to apply for it by the defendant? So these two questions refer to the main issue of proceedings, national proceedings challenging a judgment which has to be executed. And as I said before, the regulation aim is a free movement of judgment, but always respecting the right of the defendant. And therefore, the condition is that at least the defendant has the opportunity to protect himself, to defend himself. And therefore, the application for relief can be important, even beyond the deadline, the time provided by the national law. The two answers to the question by the court are very clear. You know, proceedings may challenge a judgment, but the application for relief, even when the case has expired, when the relief deadline or the deadline for the application of relief has expired, the proceeding can be referred. And second, the last paragraph of Article 19 has to be interpreted as excluding the application of provision of national law concerning the system of applying for relief where the period for filing such application has expired. So even in cases where national relief has expired, the regulation should apply. Therefore, this same idea was also referred in the trade agency interpretation of Advocate General Kokot. The fact that the default judgment was not served on the defendant until the Court of Enforcement did so, together with the declaration of enforceability, does not release him for his obligation from his opportunity to commence proceeding. And the second paragraph insists on the same idea, because what the court is saying, we have to provide with an overall overview if the defendant has the opportunity to protect or defend his own interests. So as you may understand, this enforcement of default judgment is one of the most problematic cross-border issues in practice. And that's why I have to come back to the grounds of our project, which is building European mutual trust. If you look at the aims of our diversity of enforcement titles in cross-border debt collection, and our main ideas behind our project is to build mutual trust, to understand that local proceedings cannot impede the execution of judgment. And therefore, I encourage all of you to deal with this matter in your reports so we can really provide with good practices, with recommendations with solutions, because there is still much work to do and to be done in this matter. So thank you, everyone, particularly the organizers, all of you, for listening at this time of the day. And as promised, 9 minutes. So thank you very much, Vesna.